Good evening, everyone. Tonight's focus is on the Litigation Practice Group. The Litigation Practice Group is one of the Federalist Society's 15 practice groups, which are organized by substantive areas of law. Each practice group is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. You can learn more about the practice groups at fedsoc.org/practice groups. So tonight, representing the litigation practice group is Daugherty. He will share his reflections on his 30 years as a trial and appellate litigator. I'll start by introducing him, then he will offer remarks. From there, we'll launch into a Q&A. We encourage you all to submit questions via the Q&A function at the bottom of the screen. Daugherty is a senior litigator at the Defense of Freedom Institute, an education reform group. Before entering the public interest sector in 2019, he was a partner at 3 of Wisconsin's largest firms with nearly 30 years of trial and appellate litigation experience. He has been consistently recognized as among the best lawyers in America, as well as Wisconsin's super lawyers. He received his BA from the University of Virginia and his JD from Northwestern University Law School. After law school, he served as a clerk to the Honorable Roger J. Minor of the United States Court of Appeals for the Second Circuit. Daugherty served on Governor Scott Walker's Judicial Selection Advisory Committee from 2011 to 2018. He's on the Board of Advisors for the Milwaukee Lawyers chapter of the Federalist Society and on the Executive Committee of the Federalist Society's Litigation Practice Group. Welcome, Don.
Thanks, Kendall. Appreciate the introduction. I appreciate the chance to talk with everyone this evening. Thanks for taking a break from your law school studies to listen to me. As Kendall said, my name is Don Daugherty, and among other things, I'm a longtime member of the Executive Committee of the Federalist Society's Litigation Practice Group. In the short time we have here tonight, I thought I'd relate a few observations on litigation as a career, to the extent some of you folks are interested in doing that. Maybe I'll dissuade you, maybe I'll persuade you to do it. I think it's been a wonderful career for me, but we'll talk about that shortly. I also want to touch on a few trends, I should say, that I've seen over my years. So I think that you should have, there's a URL, I believe, that links to my CV that you should have. And please understand, as an initial matter, that it was definitely not my intention to be some kind of, pompous twit or something by giving you my CV. Really, what I thought as I was praying for this, I figured that it would be good to give you some context, some background for my remarks, and save us some time if I provided that to you, so I don't have to be constantly referring to what I've done since I graduated from law school a very long time ago. And hopefully it'll be helpful in that way to you. So again, I'll try to hit on a few things I've seen and observed over my years of practicing as a litigator. And if any of the things I talk about are of particular interest to you, please ask me more in the Q&A. So the first theme I'd like to hit on is sort of talk about what it is, what is sort of the nature of being a litigator. And of course, all of these remarks are, in my humble opinion, for what that's worth, and they're not to reflect on my employer or the Federalist Society or anybody. That's my own opinions. But I think to have a successful, fulfilling, dare I say, enjoyable career as a litigator, it's important to have a competitive nature. You gotta like to win. Win-win scenarios are fine, given the number of the prevalence even of the settlement of lawsuits through mutually agreeable, kind of resolutions. That's certainly more common. But win-win is great, but it is sort of like a tie, as the sports pundits say. It is sort of like kissing your sister, and that's fine when that's the result. But you still have to have a strong preference for, not win-win necessarily, but more I win, you lose, because oftentimes it really is a zero-sum game. And by winning too, to be clear, I'm not necessarily saying winning is just a jury coming back in your favor or a judge ruling in your client's favor. In a case where the law and or the facts are against your client, winning might be negotiating a favorable settlement before the other side gets wise to your case's vulnerabilities. To me, that's a win. If you get a good resolution before they realize you've got some problems in your side of the case, that's a good result. But the bottom line is, I think competitiveness is an important trait because you're competing. I know it's not just competition. There's ethical duties and things like that that I don't mean to be dismissive of. But, again, it helps to have a sense of competition. Um, I think also to have, a good career perhaps as a litigator, you need to be comfortable with some level of stress on the continuum, say between, being bored to tears and being overly stressed. Obviously you want to have a happy medium, somewhere in the middle, but oftentimes you're tending towards this side, the overstressed side. You're not going through tax documents necessarily or that kind of stuff, but you're perhaps butting heads or dealing with things. So there is, kind of the stressful aspect of it. And the reason that is because there are a lot of things that are just outside of your immediate or direct control. You've got clients who can be demanding. They don't necessarily understand the litigation process. They're unreasonable. They don't know why it's taking so long, costing so much. You have an opponent who wants you to lose. They want you to lose. And you want them to lose to some extent. You have a judge. The judge may not like your case. The judge may not like you personally. You may be from out of state in federal court in New Jersey, as I was once, and the judge may not like you. And then you've got 12 strangers, ultimately, if you get that far, who will be your jurors. And they're likely going to decide your case. And, their decision is going to affect your career. So that's some stress. The good news, such as it is that litigators tend to get paid less, too. That's something I want to make you all aware of, than other practice groups. Not necessarily, but that's sometimes, you run into that. And if that wasn't good enough, you also get to work oftentimes longer hours in other practice areas. But, if I haven't turned you off towards the notion of being a litigator, at the same time, for me personally, I couldn't do anything else. Really, there's nothing that I'm more suited for or enjoy more than being a litigator. It's exciting, pulling together all the facts and the law of a case, packaging it in a way that is accessible, to your audience, successfully presenting it to your audience, the judge or the jury, whomever, an arbitrator. To me, that's great fun. And you get tremendous satisfaction of doing it well. And that's why, notwithstanding some of the downsides, perhaps, that I mentioned earlier, I've really, really enjoyed it. Now, there are times you can be sure when I would not have said that during the course of my career. But overall, again, at my age, I can look back and say I really have enjoyed it. And ultimately, too, as a litigator, you're really more the boss well, you're really the boss of your case. I mean, the first chair litigator, whoever's in charge of the litigation, they need to have authority and responsibility. They need to be accountable. They have to give directions, but really they need to be in charge. When you compare, for example, more transactional corporate types of practices. Now, I'm sure my friends who are in those areas will tell you all that I'm full of hogwash. But, to me, what they're doing more often is kind of like papering over deals that business people have negotiated. Or patents, the patent world. My wife is a patent attorney. She's much smarter than me. She's an engineer and an attorney. And she's I'll just say she's much smarter than me. But what she does, and again, it's very lucrative, but what she does is she secure rights on things that have been invented by someone else, which is great. Again, don't get me wrong, but as a litigator, you get to kind of, drive the action in a case, or just, drive the action in your practice area more often than perhaps some other areas, some of my colleagues. Now, again, I'm sure if you talk to them, they'll say the Daugherty is all wet. But, this is my show, so you can listen to their, practice group presentations and decide for yourselves. Another theme I just wanted to hit on, sort of, over the years, what do I think is kind of the best litigation style? Or, what is the best way to approach it? And, I guess I would say, whatever works for someone individually. I mean, there's more than one way to skin a cat. There's more than one way to get a good result in a lawsuit. I think, to athletes over the years that I've, watched, I mean, to date myself, I think back to Bjorn Borg, who was, the cool, unemotional Swede with ice water in his veins, against, John McEnroe, who was the big mouth, bossy, New Yorker. They both were tremendously successful in tremendously different styles. I think also closer to home here in Wisconsin. We had for a long time as our quarterback for the Packers. Of course, you know I was going to get into the Packers, but we had Brett Favre, who was kind of a gunslinger, a country boy from Mississippi. But then more recently, and not soon, no longer, we had Aaron Rodgers, who was more of a cerebral West Coast kind of deep thinker kind of guy. Both of them, between them, they won 6 MVPs, very different styles. I note that they only won 2 Super Bowls between them. That's a source of consternation between for us here in Wisconsin, but that's something different. So again, there are different ways of being successful litigator, and it depends on individual styles. Now, sometimes dealing with clients, they do from television or what have you, movies, etc. They have kind of preconceived notions of what a litigator should be. I mean, clients will say, I want a bulldog, I want a shark, that kind of a thing. And when I was comfortable, responding to a client, who said that kind of thing, I would say, whatever kind of animal wins cases in your mind, whatever kind of animal gets you with the results you want, be it an aardvark, be it a shark, whatever, that's what you're going to get if you hire me. So I think, there's different styles. And again, the cutthroatedness, only is it not necessary, just as kind of a, moral or ethical matter, it's really not effective, I don't think. Personally, I think it's best to keep up good relations with opposing counsel when possible. I mean, again, like they say in The Godfather, it's not personal, it's business, really. And it also helps you get to the heart of the matter more efficiently with less cost to your client, if you avoid collateral disputes. And of course, judges and courts, they hate it when the parties are bickering and getting into, pissing contests, if I can say that. Judges I know, and I've known a lot over the years and still do, at all levels, they always say, take the high road. Even if your opponent is not doing that necessarily, take the high road, because that's best. And judges will notice that. And it's always just better that way. I think it's better for yourself, and I think it's more effective too. Now, of course, I'm not saying be a pushover. You need to zealously represent your client's interests. But discovery disputes that are necessary, refusing to grant reasonable requests for extensions, those kind of things, they're a distraction. There's plenty of stuff to fight about that are real issues in a lawsuit. You need to pick your fights and focus on those. I would say that a common denominator of the best litigators is that, of course, well, they're smart, but they're well prepared. They have a command of the facts that are relevant to a case, the law that's relevant. They know their opposition. They know their opposition's case better than their opposition does. And they know their audience, that is, the judge who's presiding, or, that kind of thing, the arbitrator. They know kind of what that person may be looking for. So those are some of the common denominators, I think, of successful litigation. A third trend I've seen over the years, this isn't just some observation, unique to me, it's a matter of fact, is that there's fewer and fewer civil trials over the years. Business litigation, which is what I did primarily, it was rarely made sense to go to trial in a case. And this is almost certainly better for clients, not having to go to trial, being able to resolve something prior to trial. But it does yield fewer opportunities for younger litigators, younger attorneys, to get hands-on experience, the kind of hands-on experience that I think that I got when I was first starting, for various reasons, including the fact that, I think rates were lower. I didn't get paid as much. I got paid fine, but there wasn't as much at stake, I guess, is what I would say. And so, there was more hands-on kind of opportunities, experience for litigators early on. Just to get back to the notion of why there are fewer, trials these days in the civil world, at least. I mean, in business litigation, you take discovery, you find out through documents, you take depositions, you find out really what the real facts are. I mean, oftentimes at the outset of a case, even your client, if your client is a corporation, like often my clients were, they don't really, there's different people saying different things in the corporation. There may be some people trying to, cover their rear end because of a decision they made, that kind of thing. So you take discovery, you learn not just the other side's case, but your own. And then at some point, you reach a point where you can sort of assess the odds. You can say, well, we've got maybe, 50 to 60% chance of winning, or 40, 50, whatever it's going to be. You get a range, odds. And then you can kind of look at the number, that the monetary damages that are issued. You simply multiply them, and you get kind of a range, or settlement range. And usually things can resolve themselves through that. It's really straightforward. I think, if a civil case or at least a business case does go to trial, usually it means that one of the two sides or one of the parties has grossly overestimated the strength of their case, and not sort of looked at it clear-eyed after some discovery has been taken. Speaking of discovery, another trend that I'll just note on here is, and this is for you younger people, which you all are. This is nothing that no trend for you to see, but there has been a rise, obviously, of electronically stored information. I mean, again, I started, in 1990. I mean, we had paper back then and all that kind of thing. And much to my, for a long time, I was hoping that computers, the internet, really was more just kind of a passing fad that I wouldn't have to deal with very long. But I kind of think they're here to stay. And with that, so is ESI. So that's been a bit of a bummer, I think, for some folks. It's not uncommon to have to review terabytes of information from your client or from the other side to find out what's responsive, what's relevant, and attorney-client privilege, stuff. You need to contract and work with outside ESI vendors a lot of times. These are manageable. The ESI issue is manageable. But, from my point of view, it's been sort of an unwelcome development, which I guess brings me to my last theme then that I'll hit on before maybe I turn it back to Kendall here. And that is, how is litigating in the public interest area, which I've been doing since 2019, roughly, how is that different from private practice? And again, I was talking about ESI a moment ago. Among other things, you really don't have to deal with ESI or much of discovery for that matter when you're in the public interest area. Public interest cases, the kind that I do, you're normally suing the government, which is fun. I like to sue the government. But maybe you get some interrogatory answers, you get some admissions, you get documents through either discovery or through FOIA requests or open record requests, that kind of thing. You take a deposition or two of government representatives. Federal Rule 30b-6 is the one that allows one individual kind of to have to speak for an entire organization or for government, a part of the government. And so you take that deposition, and that kind of binds the defendant to those answers. That's not too difficult, and that's kind of fun, and discovery in the public interest sector is a lot less laborious, it's a lot less involved, it's more focused than in private practice. There still is gamesmanship like there is in private practice, mostly by the government. Now they don't turn over the documents they should sometimes with regard to FOIA requests and whatnot. They drag their feet, and sometimes you have to bring a separate suit because of that. But generally discovery is more enjoyable and gets more to the point. Is more constructive than perhaps in private practice. Also, I sort of talked about clients earlier. On the public interest side, clients are, they're sort of easier to manage, I guess, and work with. In the public interest sector, you provide services pro bono. So they can't complain about the bills, obviously, so that sort of is eliminated. And actually, the clients are almost always sort of true believers in the higher goals of the public interest litigation, or the reason you filed the lawsuit in the first place. They're usually allied with that sort of higher goal, besides the immediate interest they have for bringing the case. So clients are usually sort of like-minded, fellow travelers. Again, there can be some management issues, but they're usually very grateful. So that's I guess, another difference between what I did before 2019 and what I've been doing since. So I think that concludes my remarks. Kendall, if it's okay, if I can turn it back to you.
Of course. So the first thing I'm wondering is, you explained, now that you have been a litigator for 30 years, it's a career you could look back on and be proud of. You couldn't see yourself doing anything else. But before you entered that, how did you know you wanted to litigate? Did you know when you were in law school?
Yeah, I think I did. I guess, you're a summer associate. And again, this is just sort of, maybe whatever it's worth, what I did is, I sort of did a corporate thing one summer or half a summer, then a litigation thing the other half of the summer. And just litigation was more fun. Again, you get to win, and it's just more, enjoyable for me. I was an English major, so writing and all that kind of stuff, I enjoyed that. I was not an accounting major or things like that, so I'm adverse to numbers generally. So you just kind of figure out what you like to do, and it's good, if law firms will allow you, or if you're able to try to get different kinds of experience, for summer jobs, as well as take different kinds of classes. Take secure transactions to find out more about that side of things, creditors' rights, and then take pretrial litigation or litigation practice kind of class as well, and kind of figure out what you're comfortable with.
Okay. Looking back on your career, is there any one particular highlight that really stands out? Maybe like a proudest moment, or like a case you really enjoyed, or you didn't expect to win and you did, anything like that?
Yeah, I mean, there's been a bunch. I mean, I mean, it's hard to kind of say. I mean, I guess the one sort of proud moment, just thinking here, is I did a lot of work for the school choice movement, which, as you may know, kind of was Milwaukee, Wisconsin has sort of the longest running school choice program. And there was a case out of Ohio in the early 2000s called Zellman v. Simmons Harris, that dealt with Ohio's voucher program, and the claim was that it just benefited, sectarian schools and this kind of thing. And so I and some colleagues represented the state of Wisconsin, and we filed an amicus brief. And normally filing amicus briefs is fine. It's better to actually represent a party, but this is an amicus brief where we really could bring something to the table. And we showed in our amicus brief the empirical data, what the experience in Wisconsin had been. And it showed that it was not all sectarian schools. A lot of non-sectarian schools participated in the school choice program. And again, we made some impact because I think it was Justice O'Connor. But in any event, whoever it was cited our amicus brief, the part that I wrote about Wisconsin's experience, in a footnote. So, I guess that's that's my legacy, as a footnote in a Supreme Court case. But it was pretty cool. It was definitely pretty cool.
That was awesome. Great experience. I'm going to turn now to questions about your practice group, because I know I, as a student, don't know much about the practice groups, and I imagine other students are in the same boat. So how long have you been involved in the practice group, and what is your role with your practice group? What do you do?
I think I've probably been involved, really. Well, I was involved in the local chapter. I mean, I'm still involved in the local chapter, but I think as I kind of, had gone through all the different offices here from the Milwaukee Lawyers chapter, I think then, Leonard Leo, got me involved. Maybe the late '90s or something, maybe something like that, early 2000s, got me involved in the litigation practice group, on the executive committee, and I've been on ever since. And I don't know the number. It's a pretty big committee. And we've had, I mean, the head of the committee, the chair was Ken Starr at one point, Rachel Brand, who's very prominent. If you all know her, she was the chair of it. So we've had some people, but it's we have monthly calls, and we talk about what we're going to do, programs we're going to put on. There's the big national convention every November, so you have to put on something for that. And I've done plenty of webinars and things, on various topics that have interested me over the years. So and it also helps, if you want to write, which I've done too, you can get that sort of into the various publications that FedSoc puts out. So and it kind of, the thing is too, it kind of forces you to be involved. I mean, it's easy, to kind of just ignore that. I mean, and maybe say, I'm not going to go to a meeting, or I'm just going to, there's always more important stuff to do. But if you're, if you get on a committee or do something, it kind of forces you to be involved, which really ultimately, I think is to your self benefit.
Absolutely. And do you have any advice for any students or recent grads that want to get involved? Like, how can they get involved with practice groups?
Yeah, I mean, I don't think it's very hard. I mean, I think it's, I think you just find out, look on the website, figure out who to call, and just reach out to him or her, one of the FedSoc staffers. And they'll, we're always looking for people to help out. There's plenty of stuff to do. So again, I don't know off the top of my head. And Nate, whose last name escapes me, is the head of he's the FedSoc guy who sort of runs our practice group. I think he runs all the practice groups. But before him, it was Dean Reuter. But in any event, you find out who it is and reach out. And, people are busy. If you don't hear back, in a few weeks, follow up and keep at it. And again, if you want to get involved in the litigation practice group, feel free to reach out to me, and I'll see if I can hook you up with whoever the powers that be are.
Absolutely. It sounds like you've gotten a lot out of being part of the practice group and the Federalist Society in general. So with that, I want to thank you all for coming and being a part of this. Next week's PG-15 event is Cryptocurrency from All Angles, hosted by the University of Pennsylvania's Carey School of Law chapter. So yeah, I encourage you to come to that, and I really appreciate you guys coming this week.
Thanks, everybody. Appreciate it.
Thank you all.